Good afternoon and welcome everyone to another Surrey Law Society webinar. These webinars are provided free for the membership, and delighted there are so many of you here today to join us. Today we will be considering estate administration, anticipating and navigating the hurdles by looking in particular at a case study with Kate Selway, KC of Radcliffe Chambers. This is one of a variety of webinars and online courses, together with in-person courses and conferences that Surrey Law Society provides. Do check out the website for the full programme. In terms of housekeeping today, if you do have a question, please feel free to interject throughout the course and use the Q&A. Hopefully we'll be able to have something more of a conversational webinar today, so please do volunteer questions as and when they arise, and I will try and chair appropriately. If you would prefer to ask a question at the end, there will also be an opportunity to do so, and please use the raise hand function. This webinar is recorded and will be made available to members after the event. Briefly, I'd like to thank our sponsors today, Surrey & Co, surveyors and property management. They send their apologies. Unfortunately, they're not able to attend today, but we will be circulating some additional information regarding our kind sponsor after today's session. Welcome, Kate. Kate is a wide-ranging and successful commercial and traditional chancery practice. She's an experienced litigator and has appeared in a number of high-profile cases and represented government departments and agencies whilst on the Attorney General's panel. Kate is known for her clear, concise and pragmatic approach. Her core areas of practice are trust and, in particular, taxation of trusts, all aspects of real property, landlord and tenant, wills, probate and administration of estates, together with court of protection, some charity work, and of course advising around professional negligence and the same. Kate will present today on a case study on a matter in which she has recently advised, where the will had given a gift which did not take into account the testator's full circumstances. Kate, I'm very much looking forward to this afternoon's webinar, and I will pass over to you. Thank you, Kate.
Thank you very much, Kieran, and welcome everybody. I noticed the numbers are sort of still ticking up slightly, but hopefully any late joiners will be able to catch up pretty quickly, even though part of what I'm going to be talking about today is tax, so please don't all run away right now. Helen Opie is going to be managing the progression of the slides for me, but it'll all be pretty obvious as we go along which slide we're on, and these slides will be made available afterwards, as I understand it. So I've been asked to talk today about anticipating and navigating the hurdles in estate administration, and as you can see on that next slide, what I'm going to be talking about is the ramifications of a recent case I successfully argued for the taxpayer before first tier tribunal against the revenue. It was a case that the particular tax issue hadn't been dealt with before. So I have on occasion, and maybe some of you might even have listened to it, spoken about this case very much from the tax aspects before, but what's very instructive about this case, I think, if we can turn to the next slide, it is possible to look at it and see it as a succession of hurdles and troughs where a problem arose to be dealt with, only for another problem to arise and maybe not to be dealt with particularly effectively. And so I think it seemed to me that it was a very useful case that we could use in a webinar context, even in a seminar context. So as Kieran said, please feel free, if you'd like to chip in with questions as we go along. If either Kieran or Helen notice those questions, no doubt they'll interrupt me, and I'm more than happy to be interrupted to deal with the question as it arises. So in a moment, I'll tell you a little bit about the background and the people involved. I think to give the whole thing a human element helps us stay with it, as it were, because obviously we're going to be looking at some fairly technical legal concepts. So in a moment, I'll tell you about Mrs. Raboni and Mr. Bodger. Sometimes I get their names muddled up, so that's not a test. You'll stay with me if I get their names muddled. But I think what this case demonstrates throughout its long history, as you'll see, is a number of things. First of all, as this particular slide identifies, thinking about the first stage of what somebody wants in their will, we've got some issues with whether the will drafter did a good job understanding Mrs. Raboni's instructions. We don't know, after the passage of all this time, what precisely her instructions were, but we can see some obvious places where the will drafter may have not thought things through carefully enough. That resulted, as we will see, in quite a limited gift to Mr. Bodger. And that led to a whole series of problems, not only at the time of Mrs. Raboni's death, but also at the time of Mr. Bodger's death, a number of years later. There was a succession of misunderstandings, legal misunderstandings, some factual misunderstandings, and it finally got to me a few years ago. And I was asked various things. We'll get to that in due course. One of which was, were we right to pay £190,000 to the revenue a few weeks ago? And as you'll see, I had some quite definitive views on that. Anyway, without further ado, before we go to the next slide, I'll just tell you a little bit about the people involved. Mrs. Raboni, as I mentioned, was an elderly lady. She was a widow. She was a retired cafe proprietor. She was Italian, and she solely owned the property in Fortis Green, which is the subject of this particular case. And her husband had predeceased her a number of years earlier. And she had a very good friend who lived a couple of doors down called Rita Silver. And she had a brother. And this is where Mr. Bodger comes in. Mr. Bodger was a divorced man. He was a great friend of Mrs. Raboni and her husband when he was alive. And he would often come and stay with his sister. And after he got divorced, he actually went to live with his sister Rita a couple of doors down. And as she became very elderly, she was 89, 90, and she had a fall, and she got a bit worried about living in her house on her own. Mr. Bodger became a really great support, a staunch ally, a great support for her. And from the autumn of 2002, began to visit her regularly, help her with her shopping, all that sort of stuff. Began to stay at the property a few nights a week. She was afraid that burglars were going to come. There was a possible break-in. And subsequently, he began to stay on a more permanent basis. There was nothing sort of essentially romantic in this relationship. He was just a wonderful friend to her. And she decided when she made her last will in the summer of 2003 that she would really like to make provision for him. And she went to see a will writer, a solicitor, partner in a firm, a very experienced solicitor. I dare say she didn't want to pay a lot of money for her will. And she ended up with a will that caused no end of problems. And I will come to the will, the precise terms of the will, when we get into the tax aspects a little bit later on. But what the will drafter didn't do and what he could have done, and it's difficult to criticize him after all this time because we don't actually know what questions he asked. But Mrs. Raboni's assets consisted only of the property and probably only about 10 or 15,000 worth of other savings and assets. And what the will writer did was he gave Mr. Bodger under the will the right to occupy the property only. He did not leave a full life interest. And what he could and should have done, arguably, and maybe he did ask her and maybe he didn't, and we don't know, but this is a lesson to be very careful about the way one deals with clients in this sort of situation. Because as a result of Mr. Bodger only having a right to occupy the property, the inheritance tax liability at Mrs. Raboni's death far eclipsed the amount of cash in her residuary estate. And that set off the whole chain of problems that we encountered in this case. So as you'll see on the next slide, what I've done there is identify the conundrum that you'll see led to this escalating property. So the question was, he did occupy the property, as we will see, for the whole of the time after Mrs. Raboni's death until his own death. So he was named as a beneficiary in her will. He was given a right of occupation, but nothing more extensive than that. Subject to that, the property was to go in equal shares to Mrs. Raboni's, I have to say, argumentative nieces and nephews, and in fact, the friend Rita Silver I mentioned. Most of the nieces and nephews lived in Italy, and they were at loggerheads, as we'll see. So when Mrs. Raboni died in 2004, just over a year after making her will, when she was 92, her estate consisted of little more than her property. So her only debts and liabilities were her funeral expenses and an IHT bill of around £15,000. The residuary estate, however, was not sufficiently large to bear that IHT liability. If I remember correctly, it was the residuary estate, I think, was something like £7,000 or £8,000. So here we get to the next hurdle or pitfall, what to do. Now, the executors advised wrongly. The executors were the same firm of solicitors that the will drafter came from. Although he didn't take out the grant, he was about to retire, and he did retire. The executors advised, firstly correctly, that the property would have to be sold to pay the IHT. They then advised incorrectly that if it was sold, its value would not be a vacant possession open market value, but it would be subject to Mr. Bodger's right to occupy. And we'll unpack later on the reason why that was wrong advice. But let me just tell you what happened. The beneficiaries, the Italian nieces and nephews and Rita Silver, decided that what they would do is pay the IHT liability themselves, because they thought, why would we want to sell the property if it's going to be subject to Mr. Bodger's life interest? It will be worth a lot less. That's not good for us. We better keep hold of it. That's a better investment. But it did take them a while to come to that decision, partly because they were arguing about who needed to pay and how the IHT was going to be paid. So and none of them had a big lump sum with which to pay the £15,000 IHT bill. So the executors correctly said, well, don't worry, there's the 10-yearly, there's the annual charge, and you can pay it over 10 years. So that's what they did. And each and every year, the solicitor would say, right, you know, this is what you agreed to do. You need to pay me some inheritance tax now so that I can give it to the revenue. So that's what happened. Mr. Bodger lived for a number of years, perhaps against the expectations of the nieces and nephews. He, in fact, didn't die until 2017. And at that stage, the property was worth far more than it had been at the date of Mrs. Raboni's death, unsurprisingly, and it was in fact sold by the will trustees about 6 months later for £827,000. And what the will trustees did, thinking that Mr. Bodger had been living there all along with a full life interest, they paid the inheritance tax arising on his death, because for those of you who need a bit of a reminder about the inheritance tax liabilities, the aggregate value of the value of the property, because he had a life interest in it, so they said, had to be added to the value of his own estate, and then inheritance tax was payable on the in effect on the life interest. So they worked out that £190,000 was due to the revenue, and it's at that stage that the Italian nieces and nephews threw their toys out of the pram and said, why on earth has inheritance tax got to be paid all over again? And it was explained to them that that's what happens when someone has a life interest. They said, well, that must have been negligent of the will drafter to do it that way. There's no way our aunt would have wanted all this inheritance tax to be paid, not only on her death, but on Mr. Bodger's death as well. That's outrageous. You must have done something wrong. And that's when the whole thing came to me with a multitude of questions. Was the original will drafter wrong? Did he draft the will badly? Should he have given specific inheritance tax advice about the double whammy? Of course, we don't know. We couldn't access the will file, so we don't know what was most important to Mrs. Raboni. Was it a future inheritance tax liability, or was it, as appeared to be the case, giving Mr. Bodger a right to occupy the property with the consequences for tax that would inevitably involve? So it came to me, and amongst my musings, what I came to the conclusion about was, I'm not remotely convinced that the executors were correct to pay the £190,000 to the revenue on the basis that Mr. Bodger did indeed, and had all along, a life interest in this property because of the conundrum that will break down in stages. So as a result of my solicitors and I putting together a case to the revenue, we said, can we please have that money back? We consider the tax, although we've paid it, we consider it to have been wrongly paid. For these reasons, please would you repay it? Unsurprisingly, the revenue said no, and that's why it ended up in the tribunal. So if we go to the next slide, what we will see on the next slide is how we address the conundrum and solve it, and help. I hope the way this is explained now will help you to understand how we can avoid these sorts of pitfalls in future, because I've been told many times since this decision was reported that these sorts of situations aren't necessarily unusual, and I can see why they aren't. It must often be the case that the liquidity in an estate turns out to be insufficient to pay the IHT out of the residue, and that you have to sell an asset, the property, and that asset might be subject to someone's right to occupy. So I think this is an archetypal case for understanding how one recognizes these pitfalls and then deals with them. So I think what the way I looked at it when we argued this before the tribunal, successfully, as it turned out, is to look at these 5 questions. First of all, what is an interest in possession? Why didn't Mr. Bodger have a life interest, a full life interest in the property, notwithstanding the fact that he carried on living there? Secondly, how we unpack this is to ask ourselves the question, what is the nature of a beneficiary's interest in an unadministered estate? So there we march headlong into some really interesting case law, which after today, if you don't know it already, you can keep up your sleeve, ready to deal with issues of this sort, because it's often the case, not just in a case like this, but it's often the case where you will have to consider really what is the true nature of a beneficiary's interest in an unadministered estate. That's because you may want to query what rights your beneficiary, a client of yours, what rights a beneficiary has in an estate during the course of administration. So this has this case law has wider impacts, and very interesting it is too. Third, solving the conundrum is, what are the relevant rules governing the administration of estates? And this is particularly relevant for the way the executors need to behave when they're administering an estate, and where things, you'll see where things went wrong here. Fourthly, what was the nature and scope of the clause 3 gift to Mr. Bodger? And we will look in a moment at the precise terms of that clause 3 gift. And finally, I told you about the argumentative beneficiaries and what they decided to do, which was agree not to sell the property and pay the tax themselves. Did the actions of the executors and beneficiaries, and when I say actions, that includes the mistakes of the executors, did that somehow confer an interest in possession on Mr. Bodger? Because at the hearing, HMRC vigorously argued that Mr. Bodger did have an interest in possession. There was the will, there was what the will said, giving him a right to occupy the property. He did in fact occupy the property, the tax got paid, he lived there till his death. Why is that not an interest in possession? And so to solve that question, those were the 5 questions I posed, and we worked our way through those during the course of the hearing. So first of all, next slide, you'll see what is an interest in possession. So in a nutshell, although it's not defined in the taxing statutes at all anywhere, you have to go to, in effect, Pearson and the IRC, a 1981 decision of the House of Lords, which tells you what you need to know. And you can remember it briefly by remembering that it's a present right to present enjoyment of trust property, not any property. For example, if you've got, if you occupy a property under a lease, you'll say you've got a present right to present enjoyment of that property. That doesn't mean you have an interest in possession. So it has to be settled property. Could be an inter vivos trust, could be a will trust. So do remember Pearson and the IRC. You can also look at HMRC's IHT manual, which endorses that definition and has a little gloss on the definition. It says a person has an interest in possession when they have a present right of present enjoyment or an immediate right to the income or enjoyment of property, irrespective of whether the property actually produces income. So it's completely uncontentious that a right of residence conferred by a trust instrument will, if it confers a present right of present enjoyment, be an interest in possession. So Mr. Bodger would have had an interest in possession, most definitely, if Mrs. Raboni's residue had been sufficient to pay the tax and there was no call upon the property. but we're skipping ahead of ourselves. We haven't got to that bit yet. But that's what an interest in possession is, a present right to present enjoyment of trust property. And there's plenty of decisions that look at beneficiaries' rights in trust property, rights of occupation, which specifically spell out that a right of occupation is enough on its own. Okay, next slide. That's just a reminder to you there of the immediate post-death interest that Mr. Bodger was potentially going to get. And you'll find that in section 49A of the Inheritance Tax Act 1984. Next slide, and what this focuses on, and it's quite an important one, is the beneficiary's rights in an unadministered estate. So this is where we put our chancery hats on and work out really what exactly is going on when somebody dies, makes a will, having made a will, leaving gifts in that will. I always use the example of the Picasso. Am I going to get the Picasso that's been left to me by great aunt Julia? She said I can have it in her will. Am I going to get it? At what stage can I say the Picasso is mine? So I'm sure this is pretty familiar to all of you. A beneficiary of an unadministered estate does not have either beneficial or legal ownership of estate assets at the moment of death. They certainly don't have legal ownership. As you know, the legal title vests in the executor, or if there's an administrator in the public trustee, and then upon the grant, title vests in the administrator. Certainly doesn't vest in a beneficiary. Considering then beneficial ownership, can a beneficiary at the moment of death say the Picasso is mine? The answer to that is also no. What a beneficiary has at the moment of death and during the course of administration is an inchoate right. We can call it a shows in action to give it its legal title, but it's an inchoate right. The right to compel due administration. And we all really know that. We all know that when a state administration is flailing, when the executors aren't doing their job properly, when it's not clear what the estate accounts look like, a beneficiary has the right to compel due administration. They can ask for an account. They can pull up the executor if the executor isn't doing a proper job or not. So what happens to these inchoate rights during the course of administration? And it's that issue which has been really interestingly dealt with by the Privy Council in a case that is of some age now, a mid-60s case called the Commissioner of Stamp Duties of Queensland and Livingstone, and that the ratio of that case was approved of in Re Lee's will trusts. So if we look in a little bit more detail at that by going to the next slide, this is a really useful, and that's why I've put this quotation in full in the slides. It's a really useful piece of legal reasoning. And this is about a lady called Mrs. Coulson who died having been granted under, I think it was her late husband's will, but somebody else's will anyway, a piece of property that was in the course of administration. And she died during the course of the administration of that earlier estate. And the question was whether her estate was liable to pay a stamp duty tax on the property that had been left to her in the will. So it was important for the Privy Council to identify whether at her death she had a beneficial interest in the property that had been left to her in the previous estate. So what Lord Radcliffe did there was to discuss the nature of rights in unadministered estates. And what he said there is it may not be possible to state exhaustively what the trusts are at any one moment. Essentially, they are trusts to preserve the assets, to deal properly with them, to apply them in due course of administration for the benefit of those interested, according to that course, creditors, death duty authorities, legatees, residuary beneficiaries. They, meaning these rights, might as well have been termed duties in respect of assets as opposed to trusts. And I've underlined this bit. What equity did not do was to recognise or create for residuary legatees a beneficial interest in the assets in the executor's hands during the course of administration. This could have been done in the sense that assets, whatever they might be from time to time, could have been treated as a present, though fluctuating, trust fund. But it was never done. It would have been a clumsy and unsatisfactory device from a practical point of view, and it would have been in plain conflict, says Lord Radcliffe, with the basic conception of equity, that to impose fetters of a trust upon property with the resulting creation of equitable interests in that property, there had to be specific subjects identifiable as the trust fund. And what we'll see on the next slide is that an unadministered estate was incapable of satisfying that requirement, because when you've got an unadministered estate, you can't say at any one particular moment what the assets are going to end up being, because you need recourse to that unadministered estate out of which to pay the debts. So that's why Lord Radcliffe says the assets as a whole are in the hands of the executor, they're his property, and until administration is complete, no one is in a position to say what items of property will need to be realised for the purposes of administration, or what the residue, when it's ascertained, would consist of, and what its value would be. So they concluded in that case that at Mrs. Coulson's death, there was no trust fund consisting of the residuary estate she'd inherited from Mr. Livingston. And what the final paragraph of that extract I've put in there says is that what she has until she can properly say the administration is complete and she has a beneficial interest, is this shows in action the right to compel due administration. And if we go to the next slide, you'll see that what Mr. Justice Buckley did 5 years later was to summarise what the Livingstone case establishes. And a quick and easy route is to look at Re Lee for these 4 propositions. 1, the entire ownership of property in the estate of a deceased remains unadministered. It lies in the deceased personal representatives without any differentiation between legal and equitable interest. Number 2, no residuary legatee or person entitled upon intestacy has any proprietary interest in any particular asset. So I don't get the Picasso yet, as long as the estate remains unadministered. Number 3, each legatee or person so entitled does have a shows in action, the right to compel due administration. And finally, each legatee or person has a transmissible interest in the estate, notwithstanding that it remains unadministered. So you can assign, as you know, I'm sure, you can assign a shows in action to somebody else if you want to. So that answers the second of the 5 questions. Let's look at number 3 on the next slide. And this is where we then begin to work our way back into what happened in Mrs. Raboni's estate. So just recapping then, at the date of Mrs. Raboni's death, what could Mr. Bodgier say about his rights under Mrs. Raboni's will? Could he say, I'm entitled to occupy this property, I've got a beneficial interest to do so? Not yet. It might turn out that he is happily able to say that, but at the moment of death, he can't say that because he only has a right to compel due administration, he doesn't have a right to say that asset is mine or that right is mine and I can enjoy it now. And that's when we turn to point 3, which is to consider the duties of personal representatives. So Section 25 of the Administration of Estates Act, very obvious proposition, but let's unpack it. Personal representatives are under a statutory duty to collect and get in the real and personal estate of the deceased and, in bold, administer it according to law. And that includes, where necessary, selling specifically devised property to pay debts and liabilities where the residuary estate is insufficient for that purpose. Now, in the case of a solvent estate, you can go to Schedule 1, Part 2 of the 1925 Act, and that sets out the order which, subject to any contrary provisions in the will, that sets out the order you've got to do things. Which part of the estate do you look to first in order to discharge the liabilities? Now, needn't go through that list for present purposes, because we know that Mrs. Raboni had a very simple estate. She had a house and she had about £8,000 in her bank account, in her savings account. She had a little bit of furniture and stuff in the property, but that was really not worth very much at all. So we know, therefore, that first port of call for the payment of her funeral expenses and any other liabilities she had, including her inheritance tax liability, we know that the residuary estate was the first port of call for satisfaction of that liability. So, analysing what duties the PRs had then in Mrs. Raboni's case, it's pretty clear. They had to pay the tax, and the first asset they looked to pay the tax was the residuary estate. Lo and behold, it wasn't enough. Next port of call was obviously the property. So let's look next at then what was the nature of the gift to Mr. Bodger on the next slide. And that were the precise words of the Clause 3 gift to Mr. Bodger: a mere right to occupy. I'm sure you've all seen them drafted like this before, because sometimes if a testator if things have been set out for a testator very clearly about the possible provision he or she might wish to make, they might reasonably conclude that they only want their chosen beneficiary to occupy this property and no other. In most cases, that will be a pretty mean thing to do. And so in my experience, and I don't know whether yours is the same or different, a testator will often want to be more generous than that, because they will want to provide, often for a spouse or partner or a long-term cohabitee, they will want to provide for their beneficiary for an extended period of time. It's often the wish of a testator that they want their partner to be able to live in the property or a substitute property until they either die or remarry, is the usual way things are drafted. So it's a little bit mean to only want somebody to have the right to live in this particular property and no other. Still, that may be fine. There may be very good reasons why that's what you want to do. We don't know what happened in this case. We don't know what chats the will writer may or may not have had with Mrs. Raboni. We don't know what explanations he may or may not have given about the consequences of her very limited gift. We don't even know whether he inquired properly into the remaining assets that Mrs. Raboni had to understand whether it was inevitable that the property would have to be sold. And part of me thinks that if he had asked those questions, wouldn't it have been the case that Mrs. Raboni would have wanted Mr. Bodger to occupy a substitute property, given that she wanted him to occupy this one? was the balancing act that she wanted to draw and define really one in which Mr. Bodger was only going to be able to live in the property for a short period of time, and then it was have to be sold and the proceeds split between the nieces and nephews? We will never know, but I think one of the greatest pitfalls we as probate practitioners can avoid is to get these rights of occupation carefully drafted. So absolutely no dispute here, and the revenue didn't dispute it at all during the course of this litigation, that Mr. Bodger only had a right to occupy this property and no other. And it was accepted candidly by the revenue that if the property had been sold, then Mr. Bodger's rights would have evaporated, and that he wouldn't have been able to insist on either any part of the proceeds of sale, quite self-evidently, and he wouldn't have been able to insist on any a substitute property being purchased for him. So let's look at the next slide and work out what happened then, given what we've previously been through. So on the facts of this case, what we can say as a matter of law is, and turning to the sort of strict legal phraseology, that Mr. Bodger's inchoate rights never matured into a right to occupy under a will trust sought to be imposed by clause 3, because in short, the estate was insufficiently liquid for the IHT to be borne by the residue. And given that the assets in the estate were so limited, that meant he was in no position to insist that the property not be sold. So you can ask yourself the question, a good way of testing this proposition out is to ask yourself the question, could Mr. Bodger have said to any of the residuary beneficiaries, you are not allowed to sell this property, I'm entitled to live there? The obvious answer to that would have been, but we have no other resource from which to pay the inheritance tax. The argument might have gone on. Mr. Bodger might then have said, oh, well, you can pay the inheritance tax. They wouldn't have to do that, obviously. The beneficiaries don't have to put their hands into their own pockets to pay an estate liability. Equally, what if Mr. Bodger had said, oh, well, I've got the money, I'll pay the inheritance tax? I mean, he didn't, as a matter of fact, but what would have happened if he had said that? Well, I think the practical answer to that may have been that in order to avoid litigation, a deal may have been done. But in strict legal terms, the residuary beneficiaries were not obliged to enable Mr. Bodger to spend his own money on paying the inheritance tax liability. It seems to me quite properly they could have fallen back on the strict operation of the law and said, no, you don't have the right that you say you have, and the estate is not bound to accept a loan from you to pay the inheritance tax. It would have had the agreement of all parties. Now, what happened as a matter of fact is Mr. Bodger didn't have the money, but the residuary beneficiaries were mistaken as to the true legal position because, as I said earlier, what the solicitors had advised was that Mr. Bodger's occupation rights outlived any sale, and that if they tried to sell the property, they would be subject to his rights of occupation. That was plainly wrong advice. But the beneficiaries were under the illusion, the mistaken law, that Mr. Bodger's rights were more extensive than they in fact were. So what's the implication of that in terms of how events then transpired? Somehow did the actions of the beneficiaries and the mistakes of the executor, somehow did those things in themselves enable Mr. Bodger to say he had a right of occupation that had matured into an interest in possession. So if we look at the next slide, did the beneficiary's decision not to sell, or put another way, did the solicitor's mistake in advising the beneficiaries that his rights were more extensive than they were, did that somehow create an interest in possession? The revenue plainly thought that at some stage between the language of the will and Mr. Bodger's eventual occupation, that somehow an interest in possession came into being. But what we have to do then is to try and work out, well, we've analysed the way an estate has to be administered. Is there any other way in which an interest in possession could have arisen? And we're assisted to some extent by the case of Walden, and there isn't really any detailed case law on this point, but the case of Walden is helpful because that's a case where an executor mistake of a different sort, and I'll tell you about it in a minute, but where an executor mistake which led all relevant parties to believe that there was an interest in possession, in fact wasn't sufficient to create one. So in that case, the beneficiary under the will was given a discretionary right to occupy property. She did occupy that property, but the discretion was not in fact exercised in her favour because of a mistake or an error or a misunderstanding of the true position. No discretion was actually exercised. She just carried on living there. And at her death, HMRC said she had an interest in possession. Please can we have our IHT? And the argument there was, well, she may have carried on living there, but no discretion was ever actually exercised under the will trust to appoint that interest out to her. So she didn't have an interest in possession. So she didn't. There's no IHT liability. And the tribunal agreed that that was the case. So what do we draw from that? Two things. Neither the mistaken belief on the one hand, nor the indulgence of the beneficiaries on the other could create rights that never came into existence under the will at the end of the period of administration. So the wording of the will did not give rise to an interest in possession. So that's slightly different to our case. And it was immaterial that the beneficiary was treated by the executors and the trustees and the beneficiaries, like in this case, as if there was an interest in possession. So the long and the short of it is, well, Mr. Bodgers did occupy the property. What was his status? And it seemed to me, although the tribunal declined actually, strictly obiter, the tribunal declined to give its decision on this point, and it doesn't actually matter, but it seemed to me that Mr. Bodgers' occupation of the property was in the end permissive. So he did occupy the property. The legal status of his occupation wasn't as an interest in possession beneficiary, but rather as a gratuitous licensee. So I think that's a fairly thorough analysis of what went on in that case and why the tax issues are so interesting, because it causes you to have to analyse from scratch, really, how interests in possession arise and whether they can do so where there's a lack of liquidity in an estate that thwarts what the testatrix in this case wanted to do. There's a lot of pitfalls and hurdles there. I think I've covered most of them. I think the final hurdle that we faced in this case was the fact that the will trustees had actually paid over the £190,000. So I think a word of warning there would be if you come across cases where you've got life interest tenants, beneficiaries occupying property, and they die, and you're working out their inheritance tax liability, where this particular issue might crop up again is if you look at some of these cases, it may be that their rights weren't as strong as you thought they were, and maybe it's well worth looking into these sorts of issues when interests in possession beneficiaries die, is to go back to the situation that they were in on the death of the testator, and really see whether the interest in possession did arise, and the status of their occupation since then, because that may enable you to argue based on what's happened in this case, and it's not being appealed by HMRC. They decided they didn't even want to seek permission, so it is the decided authority in this area at the moment. You may wish to rely on it in arguing in future that no more money is payable to the revenue. The difficulty and the additional hurdle we faced in this case was, of course, we had to ask for the money back again, and it's always, I think, a little bit more difficult to persuade the revenue to give back the money you've paid to it than it is if we'd had that row to begin with. On the final slide, I've got a couple of, and this was really, I left this in from my, when I presented this as a pure tax talk, some interesting conundrums to consider. Seems to me that if the shortfall is only £1, the legal principles still apply, but in practical terms, I'm sure will beneficiaries and executors and residuary people and people who say they've got interests in possession, I dare say they're going to come to an accommodation rather than litigate over £1. And that's why I've said there, hard cases make bad law. Well, I've waffled on successfully for some considerable period of time. If we have any questions, no doubt Kieran or Helen will put them to me, because I haven't been looking in the chat box in the meantime. But Kieran, I'll hand back to you.
Okay, we do have some questions, and there was certainly no waffling at all. That was very, very helpful and thought-provoking. I had a couple of thoughts, but actually what I'd like to do is read through the questions that have popped up as we've come to the end of your presentation. So the first one, it's anonymous, is assuming an interest in possession had not been created in the will, but a beneficiary or a named person has the right to occupy an estate property, will the right always be as a gratuitous licensee? And then brackets, or can it ever be something more, or can it ever be something more than that, but not an IIP? I can repeat that question if that helps.
Yeah, I can. I understand what that's getting at. If I've misunderstood, it's potentially getting at something like this. So there is a very specific gift in Mrs. Raboni's will to Mr. Bodgett's, a right to occupy. But I can conceive of circumstances where, for example, there's simply a discretionary trust that's established by a will. But what's in the discretionary trust is a property. And it may be that the will trustees have a right to confer on a beneficiary, a discretionary beneficiary. They might appoint out that property to a trust beneficiary. If it's an appointment like that, then that will be an interest in possession. But I can also conceive of a situation where, for example, there is a property in a discretionary trust, and what the executors decide to do for the benefit of the trust fund is not appoint out the property or the right to occupy it revocable or irrevocable to a beneficiary, but rather to grant a non-beneficiary an assured short hold tenancy in it, just as a way of making money for the trust. So it will depend really on the intentions of the terms of the discretionary trust in the example I've just posed, the intentions of the will trustees as to whether they want to make an appointment out to the trust, or whether, as they could do, they could grant an assured short hold tenancy to a beneficiary or a non-beneficiary in the trust. So I think the answer to the question is no, it doesn't always have to be an interest in possession, but your paperwork obviously needs to be very clear.
Thank you. Another interesting question from Jessica Williams. Is there any argument that if a life tenant dies before the testator's estate has been finalised, or I guess ascertained, that they don't have a taxable IIP?
That's an interesting one. I think logic would dictate that what you would have to do is you would know, I appreciate there is going to be a period of time in which you may not know whether you're going to get the Picasso. So you may not know whether the gift that you've been given under the will is going to mature into an interest in possession. In Mr. Bodger's case, it plainly didn't, because there was obviously an insufficient residue. The answer during the period of administration is that at some stage you're going to know the answer to that question, and it's going to relate back to the date of death. It's not going to stop being an immediate post-death interest, you know, if it's capable of arising at the end of the period of administration. So I think the answer to the question is the situation has to be judged at the end of the period of administration. And if at that stage it's clear that an interest in possession has in fact arisen, then it does relate back to the date of death. I think that must be the logical answer, although I accept entirely there may be a period where you can't answer the question.
But I can see some serious pushback from the revenue if you try to argue that point.
Yes, yes, indeed, indeed.
Third question from Gendy Thomas. What should have happened at the point the beneficiaries paid the tax? Should there have been a transfer of ownership to them subject to a license to the occupier?
That would have been ideal, I think, yes. Subject, of course, to there being arguments from Mr. Bodger about he did have a life interest after all, and assuming no litigation, assuming everybody understood correctly what the law was. It's not clear on the facts whether the beneficiaries would have definitely wanted to sell the house, in which case, and have the proceeds between them, in which case poor old Mr. Bodger, as the revenue recognised, his rights wouldn't have survived. The beneficiaries were entitled to sell the property, pay the tax, split the proceeds.
Albeit Bodger would have had a 54 Act claim, wouldn't he? He would have had a claim under the estate. Presumably he was being provided for, so yes. 74.
Yeah, 75 Act claim. Yeah, absolutely. He had moved into the property prior to Mrs. Raboni's death, and I think it's strongly arguable that he had a valid claim under the 75 Act, yes, because I think although Rita, his sister, hadn't kicked him out, you know, that's not really the question. Was he being maintained? Query the period of time for which he was being maintained. We'll leave that to one side for all practical purposes, but yes, he probably did have a 75 Act claim. But assuming not, and assuming that the beneficiaries didn't want to pay the tax, did want to pay the tax rather than sell the property, I don't think they were bound to honour the rights that had been granted under the will, but for all practical purposes, I suspect they would have done, and it would have been sensible, absolutely, to have entered into a license arrangement at that time, and indeed for the administration of the estate in effect to have been completed by the assent of the property to them by the PRs. Absolutely, I absolutely agree that that would have been a sensible approach.
Thank you. Albeit on the basis of the misinterpretation of the rights of that would have, and that's ultimately the first and the original mistake that was made, wasn't it? It was a misunderstanding of the rights in the circumstances in which the executors and trustees found themselves.
Absolutely. I mean, what, you know, conceivably with the issue that they were having to wrestle with, and not wanting, you know, they might have been saying to the beneficiaries, had they understood the law correctly, they might have been saying to the beneficiaries, look, this presents a real difficulty here. It looks as though Mr. Bodger in fact has no enforceable rights, but if he goes off to get independent legal advice, that may not be the advice that he gets, and he may want to fight for his right to stay in the property. We could, you know, solve all this if you are willing and you don't want to sell the property at this stage, by granting him a license. And if that had been done, it doesn't seem very likely that when he eventually died, if he'd had a license to occupy for all that time, there would have been any argument that any inheritance tax would have been paid or payable.
And finally, just a question from my perspective, my interpretation then is, in the circumstances in which the estate had found itself, one of the key issues in rights of occupation is, you know, the dreaded occupant dying whilst in occupation, and that, or leaving the property and then subsequently dying within 7 years, and you've got this
double whammy.
The double whammy, the worst possible outcome, and I've seen that, thankfully not on my will, but we're advising as to the outcome of that. That wouldn't have applied because the right didn't come into existence in the first place.
Correct. Yeah.
Yeah.
Correct.
Okay. Correct. Fabulous. Thank you.
Yeah. But it isn't. It's a really interesting. It's a really interesting decision that has, you know, the more one thinks about it, some quite wide ramifications, and yeah, I mean, hurdles and pitfalls, I think is a good, could have been written in this case.
We have one final question from Emily Wiggins. Why was the estate deemed unadministered, as Mr. B had survived the deceased by 10 years plus, and all 15k of IHT on the property presumably paid by the beneficiaries?
Yes, so the inheritance tax liability in Mrs. Raboni's estate was completely dealt with, and indeed the question at which the administration of her estate was completed was in fact a question that the tribunal asked. When was her the administration of her estate completed? Was it when the final tranche of inheritance tax had been paid? Strictly speaking, yes. I think as a matter of practicality, if they'd known the correct position, they would have, the executors would have assented the property to the beneficiaries, and they'd have taken on that liability directly with the revenue. I think the will trustees, obviously because of the mistakes they'd made, regarded the administration of her estate as continuing up to a particular, I don't really suppose they gave it much thought, the administration of the estate continuing up to a particular point, and then them in effect taking over as will trustees. That may not have been the precise question that was asked. In terms of IHT liabilities, of course, the IHT liability that arose on Mr. Bodger's death was an IHT liability arising on his estate, but because he had enjoyed a settled interest, or apparently enjoyed a settled interest in a trust asset, it was the will trustees who had to pay that liability from the trust asset.
Okay, thank you. really insightful, lots to watch out for, and actually, I have to say I have a degree of sympathy for perhaps the lawyers interpreting the right as a life interest.
I think that's
I
right.
may well have fallen into that trap myself without thinking too carefully about it. But there's a huge amount to take away, and actually it's one that I think anyone who's attended today and anyone who's read this case will actually really pore over the wording, and of course the circumstances and finances and liquidity in the estate to actually see what is going to be the outcome at the end, and think very carefully about who pays the tax and how you deal with that.
Yeah, absolutely. I mean, it seemed to me I didn't have necessarily the full armory of papers that may have gone back and forth between the parties at the time, but one can see completely the executors quite rightly, I think, anticipated a possible difficulty with not recognising Mr. Bodge's rights, because that is plainly what Mrs. Raboni had wanted. Although they correctly advised that the house would need to be sold, it was just that slip about saying that it would have to be sold subject, the property would have to be valued subject to a life interest that hadn't actually come to fruition. That was their mistake. I think they were entirely right to conclude that there would be big trouble if Mr. Bodge was forced to leave the property. And that's the way they dealt with it. But yeah, thinking that he had rights that were more extensive than he did in the context of that particular case, I think was not that surprising.
We will close off shortly. I understand Gendi has raised a hand. Gendi, is there anything that you wish to contribute?
Hello. Yes, it was just to ask. You criticised the drafting or the drafting of that particular clause, and saying that, for example, they didn't give the executors the right, the trustees, to buy an alternative property, for example. But really, the reason they got themselves into this difficulty is the misunderstanding about when his life interest came into being, rather than the actual wording of the clause. Is that right?
Yes, that is right. I think the reason I was a little bit critical of the will drafter, and I say a little bit critical because, of course, we don't know. It'd be unreasonable to criticise him, and it was a him, wholeheartedly, because we don't really know what Mrs. Raboni's precise instructions were. And it may well have been, and one can see that a certain testator may well be very clear that, no, I only want X to be able to occupy this property and no other. I can see that it won't need to be sold for a bit. And if and when X doesn't want to live in this property anymore, that's fine. Then I want my residuary beneficiaries to have their turn at the assets. I think it's different if you've got a situation where you definitively want to provide for your chosen beneficiary for the rest of their life, and you won't be able to foresee the future, for example, and anticipate whether a substitute property might be better for your beneficiary. So I think when you're granting, the takeaway point, I think, is when you're granting very, very limited rights of occupation, I think as a draftsperson, you have to be absolutely sure that that's the right thing to do.
Thank you. Thank you.
Thank you. And I can recall scenarios where clients do get fixated on it must be this property, this is my home, and I can recall scenarios where it's very difficult or challenging trying to explain actually the tax consequences of what you're trying to achieve mean it just may not be possible. That sometimes has been a hurdle. Kate, thank you very much. That's been really insightful and lots to take away. Thank you everyone for attending. Thank you to Surrey for sponsoring this webinar this afternoon. Hopefully we'll stay dry. It's looking pretty grim, the forecast, and have a safe and enjoyable afternoon. Just to confirm as well that a link with a recording will be sent out, and if there is any feedback, please do report that back to Helen OP. Thank you all for attending and good afternoon.
Thanks very much.